Just want to say a few words about mediation and how you can access mediation in Australia. This is a very, very important thing to understand, and it's very fundamental to the way we do things at the Commercial Disputes Management Centre. Mediation these days in Australia is basically what many people think is what alternative dispute resolution is. In actual fact, mediation is just one tool in the ADR, Alternative Dispute Resolution Toolkit. Here's a very important point. In Australia today, when most people say you can have mediation, and we're talking about commercial disputes, they're talking about mediation once you're already locked in the litigation battle, once you've already entered the doors of the court or the tribunal. What people are not talking about enough or at all these days is how can you get to mediation early? And that is before you even start talking about going to court, before you start talking about litigation. There's not enough focus on this. And one of the key objectives of Commercial Dispute Management Centre is to bring the focus onto that very, very clearly. When you talk about access to mediation, to properly understand that, you should really be thinking mediation is part of an overall strategy to manage and resolve a dispute. And there's various stages that you go through before you arrive at mediation. And this is a very important part of the way we work with commercial disputes. Very first thing we do is to understand the dispute. And to strip it down, to analyze it and evaluate it, and then work out the best way to approach it. And once we've done that, we generate a blueprint that we discuss with the parties to the dispute, because it requires their cooperation and their collaboration to make this work. Before you even come to a mediation, there's a process that needs to be gone through, very importantly. And if you miss out on this, the chances of success at mediation will be vastly less. And that is that you need to go through basically these steps. You need to understand the perspectives on both sides of the dispute. One typical example that is used there is you take a coin and put it sideways. You can only see the side of the coin. You can't see both sides. Well, each side of that coin is one perspective on the dispute. And each person in the dispute only sees that side to begin with. They don't see the other side of the coin. So one of the jobs that we do here is to help each side see the other side of that coin, and thereby help them understand that there's another perspective on this dispute. And once we've done that, we're in a position then to start working with those different perspectives to try to move them closer to what we call common ground. And that common ground is where both those people can start to see something of the other side, so they're willing then to be more accommodating, to give way, to be willing to make some compromises in order to resolve this dispute quickly, without spending a lot of money on it, and certainly without going to court. All those steps that we use move people closer to going to a mediation. And it's at that mediation, which we call pre-litigation, pre-action mediation, not once you're already engaged and embroiled in litigation, that ensures that the chance of success, or we call it prospects of success at mediation, are extremely enhanced. These days in Australia, and this is an extremely important point to understand, is that when people say, well, mediation is everywhere, I can go to mediation, yes, that's true, but by and large, mediation in this country means mediation once you've already taken your dispute into a court or tribunal. And those mediation services now are part and parcel of the justice system for dealing with disputes once you're in litigation. So it's very, very true that mediation is literally everywhere these days in the justice system. The important point to pay attention to is when. And that the second important point to really get hold of is that mediation, as it's often applied in this country, has been basically diminished to mean no more than a hosted settlement conference, if you like, or a pit stop somewhere along the way towards your final hearing. And that literally means, if you approach mediation that way, that you are playing the game the lawyer's way. Lawyers tend to want to encourage you to first be in the court, be in the tribunal, before they start really talking to you about going to mediation. Begs the question, why? Well, I'll tell you why, and this is really the insider's knowledge here. Lawyers say that they don't think that you, the client, are ever going to be in a position where you can take the heat off your dispute and make a calm, rational decision to settle your case at mediation until the lawyers on both sides totally understand what your case is about and can give you the advice that lawyers give. But that's the way lawyers deal with it. What we tend to look at is what's the commercial way of looking at things. Do you, as business people, do you, people involved in a commercial dispute, want to do that before you can start talking to each other about resolving your dispute on commercial grounds? No, I don't think so. And I've spoken to many, many audiences of commercial people, of business owners, and when I put it to them this way, no one raises their hand to say, yes, I'd love to litigate first before I can go to mediation and try to resolve this. Almost everyone raises their hand when I ask the question, wouldn't you like to be shown a way that you can get together with the other person in the dispute or other parties early before you even talked about litigation, and to be assisted by someone who's got that expertise to help you look at your dispute in a more holistic way and look at the commercial interests involved and look at how both sides can come together quickly and resolve that dispute on commercial grounds? Absolutely they do. And this is what we recognize at Commercial Disputes Management Center, and that's why our main focus and our main objective in dealing with commercial disputes is always to use the mantra of early resolution, going through a set of steps, which is to contain the dispute, de-escalate the dispute, effectively manage the dispute, and then lead the parties to early resolution. That's the way we approach things. I think when I talk about commercial disputes, it's important that I explain to you how things are different if you can reach a dispute early and before people decide to take it to court and litigate, and the situation once people are in litigation. The whole system that we call litigation is based on confrontation. It's based on power plays. It's based on assertion of superior rights over someone else's rights. It's based on someone being a winner and someone being a loser. It's based on lawyers building evidence to show your case is strong and the other case is weak. The whole system is confrontational once you're in litigation. The whole system, once you're in litigation, is polarizing. It's all about one party demonstrating superiority in their case on legal grounds, on the adducing evidence to win against the other party. That's the whole making of litigation. And so if you have a commercial dispute, and you enter into that domain, into that environment, I think you can readily understand that it tends to drive people apart. And as it drives people apart, as each one is striving to be the ultimate winner, knowing that the other party will be the ultimate loser, and under the legal system, the loser pays, they're ordered to pay the costs of the winner, the longer that goes on, the further people are driven apart. And so in that context, I think it's probably not hard to imagine that if you had done that and each side had spent considerable money on it, and some of these legal disputes or commercial disputes, once they're in court, can drive up costs very, very quickly. If someone then, after you've incurred maybe 20, 30, 40, 50, even more dollars in your legal costs, says, well, let's go to mediation now, you're probably most naturally going to ask, well, what about my legal costs? Who's going to pay them? So that becomes an immediate problem in the whole process of settlement. And you need to understand this as well, because in the justice system, when people talk about mediation, which is really the only tool that they talk about in terms of alternative dispute resolution, other than going to trial, going to a final hearing, and having a judge make the decision for you, is this trip to mediation. Now, that trip to mediation, you need to understand exactly what it means in reality. I call it a hosted settlement conference. In this country, and the way that this is now being used in the legal system, in the justice system, mediation really has become simply a pit stop where a mediator acts as carries out some sort of a shuttle service between two sides who are basically horse trading and bargaining, trying to strike a settlement in basically desperation in many cases, because the trial now is just around the corner. And usually they're doing it under extreme emotional strain and duress, because now a key factor in this so-called mediation is that if we now don't work this out, and we have to go to this trial, we have to go to this hearing, now, months down the track, if not years down the track, we're being told, each of us, we may not win. We may not win. It's not guaranteed. And if you spend all this money, so that's when clients, you business owners, are starting to feel extremely uncomfortable and under enormous pressure, because now the language has changed from your lawyers. It's not now, it's a lay down misere, it's a guarantee you're going to be the winner. No, it could go either way. This is often the environment and the basis that lawyers to themselves say, we need to get our clients in this state before they're going to be able to say, let's call it quits, let's make a bargain, let's make a deal. We don't want to go to this scary thing called a trial and a hearing now, because who knows who's going to win. And there's a saying there, and honestly, any lawyer who speaks truthfully to you will say there are hardly any winners or grinners in litigation at the end of the day. So this is what mediation has become, if you like, in this country once you're in litigation. There is a better way, and this is what we focus on. And that is, here's the big thing to keep in your head up front. Litigation is the last resort, not the first. It's the very last resort. What comes first is what we say, which is to contain the dispute by managing the communications, by calming things down, by de-escalating the tensions. I mean, doesn't this make sense to you if you could be offered this service? To bring the parties into a better dialogue, to do this with skilled expertise made available to you, to help you manage your conversation, to help you see the other perspective, to help you highlight what are the commercial interests at play here, to help you understand what the legal framework is, but not to get totally bogged down in that, so that you can no longer feel in control of the commercial interests. So most certainly, and I don't disagree because I'm a lawyer, is that you should understand your legal position. But that's just one of the things that come into play when we work with people in a commercial dispute. Far more important than that is ultimately understanding what your commercial interests are. Just to give you an example, if you could understand this in its proper, full context, that someone could say to you something along these lines, you know, the way on what you've told us, if this was to be accepted all the way through the litigation process to a trial, and this was all accepted, the law is probably on your side, and you'll probably be the winner. But in order to establish that, you have to commit to the whole litigation process. And it's very costly. And it's very stressful. And it will be very disruptive to your business. It will distract you from your core business. It will keep you away from your business. It will put a great strain on your cash flow. These are the things you have to take on board, not just, on my facts, am I going to be the winner? Is the law on my side? Now you're going to vindicate that for me. This is the language of the litigation lawyer. So we don't speak that language here. We'll ensure that you understand your legal environment that you're in and so on, but we put up front, what is important to you commercially right now. And if you could exit this dispute within the next few weeks or a month maximum, even if at the end of the day you had to accept a result that might be less than what someone else might tell you, might be your full outcome if you sought to vindicate your legal rights by going to trial, we try to show you the whole picture holistically so that you can balance it up. So you can see, I could go this way in litigation, but I have to be willing to pay the price. Am I willing to pay the price? Or would it be better for me to get out of this dispute quickly and maybe take less, but something I could live with early and get back to business, get back to what I really want to do, rather than spending the next 6 months, 12 months, 18 months, or 2 years locked in legal battle where it's a battle to the end, if you like, battle to the death. Can only be one winner and one loser. Do I want to take on all those risks? Or do I want to try to get out fast, just do some kind of acceptable commercial deal, get the monkey off my back, get back to work, and get on with what I really want to do? That's the difference.